State laws from Pennsylvania and Rhode Island authorized public support for religious instruction in private schools. Teachers' wages and classroom resources dedicated to non-religious topics were all covered by a statewide appropriation in Pennsylvania. The laws in Rhode Island gave private elementary school teachers a 15% pay raise. Petitioner Alton J. Lemon argued that Pennsylvania state laws granting financial support to religious non-public schools were unconstitutional since they provided excessive involvement between government and religion. However, respondent David H. Kurtzman disagreed, stating that the laws did not endorse or promote religion, but instead provided education with necessary financial support. The laws involved in this case were the Establishment Clause of the First Amendment of the U.S. Constitution, which states that, quote, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, unquote. Additionally, this case involved the 1969 Rhode Island Salary Supplement Act, which gave extra financial support, quote, to teachers in non-public schools at which the average per-pupil expenditure on secular education is below the average in public schools, unquote. Finally, this case also involved Pennsylvania's Non-Public Elementary and Secondary Education Act, which restricts public school funding on, quote, subject matter expressing religious teaching or the morals or forms of worship of any sect, unquote. Does the Establishment Clause of the First Amendment prohibit state funding for non-secular private schools? Because the state laws promoted excessive government involvement in religious education, the court ultimately found that they were unconstitutional. Justice William O. Douglas concurred that government grants and other funding for religious teachings in non-public schools constitute an entanglement that is prohibited by the Establishment Clause. Ultimately, this case resulted in the establishment of the Lemon Test, a three-point test that helped regulate future government legislation regarding religious practices. In his dissent on the court's ruling, Justice Byron R. White noted that the government's use of state funds in non-secular schools created an obstacle to secular education, since it was not legally possible for, quote, the government to police the teaching practices of a religious school or university, unquote. Lemon v. Kurtzman reaffirms the constitutional principle of church-state separation and remains a landmark in the ongoing debate about the appropriate relationship between religion and government. However, it also sparked controversy regarding what constitutes excessive entanglement under both state and federal laws when the government becomes involved in religious organizations. Overall, this ruling highlights how government interference in religious freedom affects an individual's rights and how government regulations can impact those rights. According to Wisconsin state law, children were required to attend public schools until the age of 16. Although state petitioners argued that they were in violation of these laws, respondents Jonas Yoder, Wallace Miller, and Audie Nuzzi felt it was contrary to their faith to continue their children's public education past the 8th grade. The laws involved in this case were the Establishment Clause of the First Amendment of the U.S. Constitution, which states that, quote, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, unquote. Additionally, this case involved the Wisconsin Compulsory School Attendance Law, which stated that, quote, any person having under their control a child who is between the ages of 7 and 16 years shall cause their child to attend school regularly during the full period in hours, unquote. Did Wisconsin's school attendance laws violate the First Amendment by criminalizing parents who refuse to enroll their children in school until age 16 for religious reasons? The benefits of public education claimed by the state of Wisconsin were not enough for the court to uphold the legislation. Therefore, the court ruled that the state's high school attendance mandates interfere with the essential lifestyle outlined by the respondents' religious beliefs. Chief Justice Warren E. Burger spoke for the majority, citing that the state's interest in ensuring that its citizens had access to public education was at odds with the First Amendment's protection of religious liberty, arguing that the state law, quote, interposes a serious barrier to the integration of the child into the religious community, unquote. Although he ultimately sided with the majority, Justice William O. Douglas partially dissented, noting that children's opinions on their education should also be taken into account, stating that, quote, the education of the child is a matter on which the child will often have decided views. They may want to be a pianist or an astronaut or an oceanographer. To do so, they will have to break from the religious tradition, unquote. According to many legal scholars, Wisconsin v. Yoder reinforced the First Amendment's guarantee of free exercise of religion. However, some critics have argued that the ruling allows parents to neglect their children's education and therefore may not be in their best interest. Although I believe that individuals' rights to free expression should not be subjected to government interference, the government also has a responsibility to protect the well-being of children when said expressions imposed on them by their parents may potentially cause harm. According to Louisiana state laws, public schools were required to teach both theory of evolution and science classes, as well as creation science, a biblical theory claiming that advanced life forms appeared abruptly on Earth, and that neither theory could be taught separately without the other. Petitioner Edwin Edwards argued that the state laws were unconstitutional since they promoted religious doctrine in the form of creationism in public schools. However, respondent Don Aguilard argued that the law promoted academic freedom rather than government endorsement of religion. The laws involved in this case were the Establishment Clause of the First Amendment of the U.S. Constitution, stating that, quote, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, unquote, as well as the 14th Amendment, which states, quote, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process or law, nor deny to any person within its jurisdiction the equal protection of the laws, unquote. Additionally, this case involved Louisiana's Creationism Act, which, quote, forbids the teaching of the theory of evolution in public elementary and secondary schools unless accompanied by instruction in the theory of creation science, unquote, which is defined as, quote, the scientific evidences for creation or evolution and inferences from those scientific evidences, unquote. By mandating the teaching of creation science and evolution education in public schools, did the Louisiana law violate the Establishment Clause of the First Amendment as applied to the state by the 14th Amendment? By using the three-pronged test developed in the outcome of Lemon v. Kurtzman, the court ultimately ruled that Louisiana's state laws on religious teachings in public schools were unconstitutional. Justice Brennan concurred on this ruling, stating that, quote, the classroom will not purposely be used to advance religious views that may conflict with the private beliefs of the student and their family, unquote. Justice Antonin Scalia and Chief Justice William Rehnquist dissented, criticizing the majority's use of the Lemon test to determine their ruling. Additionally, they argued that Louisiana's intent for their state laws was to, quote, find considerable support in the legislative history, unquote. Edwards v. Aguillard continues to be a frequent topic of legal and political discourse about the appropriate role of religion in public education, in which scholars have criticized the outcome for relying on a single religious view not shared by all Americans. Overall, this case represents a significant victory for constitutional protection against government endorsement of religion under the First Amendment.